strike, there was an ongoing discussion, or there had been an ongoing discussion between themselves and as a trade union and Dangote and the federal government, as an impartial arbiter, had also tried, as was also the correct way to state it, is that alternative dispute resolution was ongoing, and without prejudice to that, they did not even wait to exhaust, the process, and they went on strike. And this is where I would like to take it from. Is it appropriate, or could it be said to be legitimate for a trade union like Pengasan, to do anything synonymous with the declaration of strike in the process of an ongoing alternative dispute resolution? I don't think so. And why did I say I don't think so? Is no other reason than Section 4 of the trade, that actually lays down Section 4, Section 6 of the Trade Dispute Act. Now, a community reading of this provision act of going through alternative dispute resolution, starting from internal dispute settlement machinery mechanism to mediation to conciliation to industrial arbitration panel, before, and even to the National Industrial Court reference of the matter, before we can now looking at the provision of strike. Now, Section 18 of the Trade Dispute Act was now very emphatic on the fact that in the event a trade union of employees, fails to exhaust this procedure, they cannot go on strike. And also employer cannot also lock out, except they exhaust this procedure. So that's to tell you that in declaring strike or anything synonymous to it, there is a law that regulates it. And I think this is what Pengasan did not do, or this is what they did not exhaustively look at, before going about that seeming declaration of strike. And I think vision of the law, or acting in abeyance of the law, this to the best of my mind is an area I think they may need to work on, because nobody functions in isolation. We're all product of the law. So as long as they fail to work on this, I don't think it is appropriate for them to declare strike.
Thank you, Barrister Ere Oluwa.
Hello?
Yes, I'm with you. Can you hear me?
Yes, I can hear you.
Yeah. Now, I want to ask, thank you for helping us unpacking in that pedigree. Now, I want to ask, and there are some quarters that says in Nigeria we have other private organizations like private universities, where we have TUC, we have Nigeria Union of Teachers, we have lecturers going on strike. And anytime lecturers are going on strike in public institutions, they never bother private organizations, they never bother private universities or private secondary schools, and some other private institutions too in Nigeria. When they go on strike, they never bother them. Why is it that somebody who is trying to take Nigeria out of the conundrum, out of what Nigerians have been facing for long, now some people, some organizations are now enforcing law on him? What I mean is there a law that regulates that Dangote refinery staff must join Pengasan? Because when we have private university, whenever they are going on strike, nobody disturbs them. All the public institutions, they go on strike, they never disturb private universities. Is there a law that said it is a must?
So let me quickly. You've put a lot of questions in one, so I will unwrap it one after the other. Now, with respect to joining an association or belonging to an association, whether you are a private employee or you're a public employee, you have the right to belong to an association, freedom of association.
Yeah.
And that is contained in Section 40, 1999 Constitution, Section 9, Subsection 6 of the Labour Act,
Yes.
Convention 87 of the ILO Convention, which is freedom of association and protection of right to organize, and Convention 98 of the ILO Convention, which is right to organize and collective bargaining.
Yeah.
But if we look beyond this, we now also look at the nature of the employees that are involved. For example, if it is a senior association, we have the principle of contracting in and contracting out. So for senior association, you cannot fault them. For employees that wants to belong to a trade union, that's a trade union that covers senior employees, you cannot force them to join. That is, it is not automatic. That is, they have the right to contract in and also contract out. Contracting in is belonging. Contracting out is the freedom to say they are not joining. But if we now juxtapose it with trade union of junior workers, for junior workers, it is implied that they are already in, but they may also choose to understand. So if I may answer your question, with respect to the lecturers in us, it's freedom of association, and I've already cited all the laws that regulate it. They may choose to belong, they may choose not to belong. You know, so is an is Section 12 of the Trade Union Act is also very clear on that. Now, talking about declaration of strike, you know, the trade union can declare strike. There is no law that says they cannot declare strike. In fact, if we look at Section 40 of the 1999 Constitution, the right to freedom of association, the corollary of that right involves declaration of strike. If we also look at Section 39 of the 1999 Constitution, strike is a way of expressing yourself to say that you are not satisfied with what the employer is doing. However, for any law that we have, you know, for every right that you have, you also have a law that regulates it. So we can say that there is a law that regulates the declaration of strike. There is a law that regulates the declaration of strike, you know, which is what the trade unions need to be aware of. So you can't just come one day and declare strike. You understand? In fact, I know for certain that Section 26 of the Trade Union Act says that before you declare strike, you must have given a notice to the employer, 15 days prior notice. So those are the things we should be talking about. These are the laws we should be considering whether it was fulfilled. But as far as declaration declare strike, state that, you know, under the proviso that they comply with the regulatory requirements.
Thank you, Mr. Ere Oluwa. Now we are looking at the aftermath of the fiasco between Pengassan and Dangote Refinery. Now there is a threat or a word of caution by TUC chairman and even Pengassan president in person of Festus Osifo that if the agreement is breached, the union will resume strike action without notice, without any notice at all. How do you see this statement? Perhaps there is an infringement. Wouldn't it lead to high cost of transportation on Nigeria? Wouldn't it impact on Nigerians? Hello.
Hello. Yes. Okay. So if I get you correctly, you are talking of this the economic implication of the declaration of the strike. So I've been able to speak on the legal implication. So your question is how declaration of strike is going to lead to increase in transportation expenses. Of course, I can't agree more with you. It will, and we should also forget the fact that, you know, oil and gas has been a critical sector in Nigeria, and that has experienced a checkered history. It has experienced its good side and bad sides. There are times that as a result of the failure to distribute oil or fuel, you know, throughout the country, there was long queues at the filling station and increase in transportation expenses. And we also just a few years ago, subsidy was removed, and it also led to a lot of furore until we seem to be having a sort of stabilization in the sector because of the investment of Dangote. Yes, I agree with you. And I would also say that in extending the discussion, anybody that invests, you know, would also be able to reap the product of his investments. This is a company that the person that invests would also want to make profits. So to that extent, I agree that declaring the strike would have its own economic implications. So those are the things that we should be considering before taking some actions. For me, I wouldn't know, and I can't even rationalize a situation whereby a group so-called trade union would on behalf of 800 employees now want to hold the whole of Nigerians into comatose. For me, it doesn't make sense. So I believe that ab initio, the procedure they should have gone through ab initio shouldn't even have been strike, because that doesn't favor anybody. it cripples the economy, and it cripples the economy. That with the money that we don't even have. I can imagine within this short period how much Nigeria would have lost. In this issue. So I think ab initio they should have looked at alternative dispute resolution for the purpose of exhausting it totally. And with the courage of conviction of wanting it to work, not now deviating and looking at looking at declaration of industrial action.
Oh, thank you so much, Barrister Iriolua. We are really enjoying your analysis on this show. Now, while the negotiation was going on, something came up during the negotiation which we are privy to. There is a statement made by Mr. Osifo. He said when the people were hired, they were given individual letter, but when it comes to termination, one single letter was used to throw all of them out. Did you hear me right?
I didn't get that. You said the people were giving individual letters
when they were hired as staff of the company, but when they want to throw them out, they were giving one single letter. Is this lawful? And if it is lawful, can you please back it up with explanation?
Okay, so on that, if that is the case, if the scenario he painted was the case, I would say that this is not appropriate, because contract of employment is personal. It is not collegial. Contract of employment is not collective. It's a personal obligation between an employer and an employee. So to that extent, I would agree that, to the extent in which a contract of employment is bet or conceived by an individual, by an offer of employment which is executed between the employer and employee, termination should also be treated in the same way. Let's even consider the fact that let's assume that they may even want to declare redundancy. Assuming Dangote wants to declare redundancy, it should be individually communicated to the employees. So I wouldn't subscribe, even by law. The law doesn't subscribe to a situation whereby in terminating you give a collective letter of termination. That's not even termination. Let's even talk about that's not termination, because if you employ 10, you employ them individually, and the termination clause is contained in their contract individually. So you cannot terminate them collegially. That's not appropriate, and I know that has been pronounced on by the National Industrial Court, Cooperative Commercial Bank against Amadi Rose. That's the case. So when you want to terminate someone, you can't terminate collectively. You need to terminate individually, because the termination clause is contained in the contract of employment. And again, a contract is a document between two parties which is enforceable by law. So assuming the employees too, assuming they want to terminate, would they now put themselves together and now terminate collectively? That's not possible. So if that's a scenario, if the scenario you painted was actually the case, I think that's inappropriate. But that notwithstanding, I still think that can be remedied. You understand? I still think that can be remedied. But in any event, I'm very elated that parties have been able to sheathe their swords and resolve their differences. And I will say that there is no winner, no vanquish in this, because they're able to arrive at an amicable resolution. And I particularly give kudos to the federal government, by apprehending the disputes at a very critical time so that it doesn't snowball into something bigger. So federal government play a bigger role. Kudos to them.
Wonderful submission, Barrister Iriolua Ogotuashe. We really enjoy you. But before you go, I have two more questions for you. As a labor lawyer, something came up during the negotiation too. We heard that Dangote Refinery offered to pay the sacked workers for 5 years to continue stay in their homes or do other things, but they will be paid every month. Can you hear me? He said they will pay them every month, but they will not be allowed to come closer. They will not be allowed to come close to the refinery because they don't want them to be sabotaged to the refinery. Sir, had they been the union agreed to this offer, do you see Dangote Refinery living up to this promise? And is this obtainable anywhere in the world? No, someone will not work for you and you keep paying him or her salary every month. Is it obtainable? Do you even see, even if the union agree? Do you see? It's funny.
Well, I'm not Dangote. I don't work in Dangote. I'm not part of their management staff. So I may not be able to I may not be able to give you a definitive answer on whether if parties have agreed to the promise of continuous payment of salary, whether they'll be able to keep to it. All I know is that when there is a dispute, in resolving the dispute, proposal have been brought up, and the proposal are agreed on by the parties by the principle of pacta sunt servanda, which means promise once made is absolutely binding. Parties are supposed to keep to their respective obligation. That's all I know. So to that extent, I can say that if that is assuming they agreed on that, then the party that is supposed to perform is under an obligation to perform. So that for that, you ask another question. Sorry, let me quickly.
I have one more question. I said, is it obtainable anywhere in the world where you will say somebody will not work but you'll be paying the person? Is it obtainable anywhere in the world?
I don't think it is. The law doesn't subscribe to that, because the reason the law doesn't subscribe to consideration is an important ingredient of a valid contract, and the consideration is that you work and you get paid. So if you don't work, you ordinarily should not get paid. So it follows. So the basis upon which a contract of employment is hinged or premise is on the basis of work. So several times employers have brought out the principle of no work, no pay, and the law have also legitimatized it. So if I engage you to work for me and be productive, and you deliberately choose not to work, why should I pay you? Because by choosing not to work for me, which is the base of the contract, you've even breached the contract in the first place. So if you breach the contract, then I'm even the opposing party, that is, the employer can, on the basis of that breach, initiate effort to terminate your contract of employment. So when you talk of employment contract, it is based on consideration, executed consideration. Parties would have first performed his promise. Parties would have first performed his promise before another person perform his. So that's it.
So lastly, lastly, Barrister Oguntuashe, we really appreciate you. I know you want to go. I want to ask, what script does Pengaston Dangote fiasco poses to the international organization that want to come and invest in Nigeria oil and gas industry, based on what went down?
Of course, it poses a lot of threat, because there is nobody. It poses a lot of threat because there is nobody that will want. There is nobody that will want to invest in a volatile area, or in an area whereby some people will just come and start controlling it. So it poses a lot of threats. So apologies, I may need to run now.
Thank you so much. I've told you that will be our last question. Barrister Ireoluwa Oguntuashe, we really appreciate you for your contribution and wonderful submission on this show today. Thank you so much.
Thank you so much. I appreciate you. Yes, I appreciate you. Thank you.
That was Barrister Ireoluwa Oguntuashe helping us to unpacking the aftermath of fiasco between Dangote Refineries and Pengaston.